explaining the legal process of a lawsuit. Welcome to the Law Spectrum, where we break down complex legal concepts into simple, easy to understand explanations. In today's video, we're going to explore the legal process of a lawsuit. If you've ever wondered how a legal dispute moves through the court system, or what steps are involved in filing a lawsuit, this video is for you. Let's dive in and take a closer look at how a lawsuit works, step by step. What is a lawsuit? Before we dive into the details of the process, let's first define what a lawsuit is. A lawsuit is a legal action taken by one party, known as the plaintiff, against another party, the defendant, in a court of law. The goal of a lawsuit is usually to seek justice, whether that's through compensation for damages, injunctions to stop certain actions, or other legal remedies. Lawsuits can arise from a variety of disputes, such as contract breaches, personal injury claims, property disputes, or even defamation. Now that we know what a lawsuit is, let's break down the steps involved in the legal process. A lawsuit is a formal process, and it follows a specific procedure to ensure that both parties have a fair chance to present their case. Step 1. Filing the complaint, plaintiff's side. The first step in any lawsuit is the filing of a complaint. This is done by the plaintiff, the person or entity that is bringing the lawsuit. The complaint is a formal document that outlines the legal claims being made against the defendant, the facts that support those claims, and the legal remedies the plaintiff is seeking. The complaint is filed with the court, and once it's submitted, the court will assign a case number and schedule the case for further proceedings. It's important to note that the complaint must be filed within a specific period of time, known as the statute of limitations, which varies depending on the type of case. For example, in personal injury cases, the statute of limitations might be 2 years, while for breach of contract claims, it could be longer. If the plaintiff misses this deadline, they may lose their right to file the lawsuit. Step 2. Serving the defendant. Notice of lawsuit. After the complaint is filed, the next step is to serve the defendant with a copy of the complaint and a summons. This is a formal notice that the defendant is being sued and must respond to the lawsuit. The defendant needs to be properly notified so they have the opportunity to defend themselves. Service of process can be done in several ways, such as through a process server, by mail, or even in person. The rules for serving the defendant can vary depending on the jurisdiction and the type of case, but it's essential that the defendant is given proper notice of the lawsuit. Once the defendant is served, they typically have a set period of time, usually 20 to 30 days, to file a response to the complaint, which is called an answer. Step 3. The defendant's answer. The defendant's answer is their formal response to the plaintiff's complaint. In the answer, the defendant will admit or deny the allegations made in the complaint. They might also raise defenses or counterclaims, where they argue that they shouldn't be held liable for the plaintiff's claims, or that the plaintiff is at fault in some way. For example, if the plaintiff claims that the defendant breached a contract, the defendant might admit to the breach but argue that they were not responsible for the damages. Or the defendant might claim that the plaintiff didn't fulfill their own obligations under the contract. The defendant's answer is crucial because it sets the stage for the next steps in the lawsuit. If the defendant doesn't respond within the time allowed, the court may enter a default judgment in favor of the plaintiff. Step 4. Discovery. Once the complaint and answer have been filed, the next phase is called discovery. Discovery is the process where both parties gather information and evidence from each other to build their case. This is a critical part of the lawsuit process because it allows each side to understand the other's arguments and evidence before going to trial. There are several tools used during discovery, including interrogatories, depositions, requests for documents, and requests for admissions. Interrogatories are written questions that one party sends to the other, asking for information related to the case. Depositions are sworn statements taken from witnesses or parties involved, often conducted in person with an attorney present. Requests for documents allow one party to ask the other to produce specific documents related to the case, such as emails, contracts, or photos, and requests for admissions ask the other party to admit or deny certain facts. The goal of discovery is to ensure that both parties have access to the same information, which helps prevent surprises during trial and allows each side to prepare their case effectively. Section 6. Step 5. Pretrial motions. After discovery, there may be several pretrial motions. These are legal requests made to the court before the trial begins. One common pretrial motion is a motion to dismiss, where the defendant asks the court to throw out the case, arguing that even if everything the plaintiff claims is true, there is no legal basis for the lawsuit. Another common motion is a motion for summary judgment, where one party asks the court to rule in their favor without going to trial, arguing that the facts are clear and there is no need for a trial. If the court grants a motion for summary judgment, the case may be over before it even reaches trial. These motions help streamline the case and can sometimes result in a case being resolved before trial. Section 7. Step 6. Trial. If the case isn't dismissed or resolved through motions, it moves to trial. A trial is where both parties present their evidence and arguments in front of a judge or jury. The plaintiff goes first, presenting their case and calling witnesses to testify. The defendant then has the opportunity to cross-examine the plaintiff's witnesses and present their own evidence and witnesses. At trial, both sides have the chance to make opening statements, present their case in chief, and make closing arguments. After all the evidence is presented, the judge or jury will deliberate and come to a verdict. In a jury trial, the jury decides the outcome, while in a bench trial, the judge makes the final decision. The trial is the most public part of the lawsuit process, and it can be lengthy and expensive depending on the complexity of the case. Section 8. Step 7. Judgment and appeals. Once the trial is over and a verdict is reached, the court will issue a judgment. If the plaintiff wins, the court will typically award damages, which could be monetary compensation for the harm caused by the defendant's actions. In some cases, the court may issue an injunction, ordering the defendant to stop certain actions or do something specific. If either party is unhappy with the verdict, they may file an appeal. An appeal is a request to a higher court to review the decision made by the trial court. The appellate court will review the trial court's procedures and decisions to ensure that the law was applied correctly. If the appellate court finds that there was an error, they may overturn the decision or send the case back for a new trial. It's important to note that not every case can be appealed, and the process can take time, often months or even years. Section 9. Enforcement of judgment. After a judgment is issued, the winning party may need to take steps to enforce the judgment if the losing party doesn't comply voluntarily. This could involve garnishing wages, seizing property, or other legal measures to collect the awarded damages. Enforcing a judgment can be a complex process, especially if the losing party refuses to pay. In some cases, the winning party may need to go back to court to ask for help in enforcing the judgment. Conclusion. That's a breakdown of the general process of a lawsuit, from filing the complaint to the final judgment. While every case is different and may involve additional steps, this process provides a basic framework for understanding how lawsuits work in the legal system. If you found this video helpful, don't forget to like, subscribe, and hit the notification bell for more legal insights. Have questions or want to know more about any part of the process? Drop them in the comments below and we'll be happy to help. Thanks for watching and